हाय फ्रेंड, नमस्कार। कंपनी लॉ अपडेट में आपका स्वागत है। रीजनल डायरेक्टर साउथर्न रीजन reducing the penalty imposed by the Chennai ROC in the case of Gopuram Enterprises Limited for the non-appointment of the company secretary. Dear friend, in this case, an appeal filed under section 454 subsection 5 of the Companies Act by appellant against the order passed by the ROC Chennai under section 454 subsection 3 for default in compliance with the requirement of section 203 read with rule 8A of company appointment and remuneration of managerial personnel rule 2014. As per section 203 subsection 1, every company belonging to such class or classes of company as may be prescribed shall have following whole-time key managerial personnel: managing director, chief executive officer or manager in their absence, a whole-time director; company secretary, chief financial officer. Further, as per the rule 8 of company appointment and remuneration of managerial personnel rules, every listed company and every other public company having paid up capital 10 crore or more shall have a whole-time key managerial personnel pursuant to rule 8A effective from 9th June 2014. Every company which has paid up capital of 5 crore or more shall have a whole-time company secretary. In this case, company being an unlisted private limited company with paid up capital 7.78 crore failed to appoint whole-time company secretary within 6 months from the date of the casual vacancy, that is 28 June 2019, in accordance with section 203 subsection 4 of the Companies Act. An appointment of company secretary is not applicable to the company with effect from 1st April 2040, as the limit of the paid up share capital prescribed under rule 8A is increased from 5 crore to 10 crore. तो यहाँ पर क्या हुआ था कि जब लिमिट भी 1 अप्रैल 2020 से इंक्रीज हो गया था तो उस केस में वो अप्लीकेबल नहीं हो रहा था। लेकिन मीनवाइल क्या हुआ कि जब कंपनी का पेड अप कैपिटल था 7.78 करोड़, तो उस समय जब कैजुअल वैकेंसी अपॉइंट हुई तो कंपनी सेक्रेटरी अपॉइंट नहीं हुआ, बाद में जाके लिमिट भी इंक्रीज हो गया, जैसे लिमिट 10 करोड़ हो गया था कंपलसरी अपॉइंटमेंट ऑफ द होल टाइम कंपनी सेक्रेटरी. However, the company should have filled the casual vacancy by 29th December 2019, thereby contravenes the above provision for a period of 94 days from 29 December 2019 to 31st March 2020. ROC Chennai examined the said default and passed the adjudication order dated 25th November 2021 under section 454 subsection 3 and 4 of the Companies Act for default in compliance with the requirement of section 203 read with rule 8A and impose a penalty of 5 lakh upon the company and 1,44,000 upon the whole-time director for 94-day delays. Appellant have contended the impugned order and pleaded that the delay had occurred due to unavoidable circumstances and default was unintentional. Opportunity of being heard was given to the appellant. The authorized representative Sri Sumit Agarwal, practicing company secretary, has appeared for the appellant while reiterating the ground taken in the appeal, has stated that company was into operational losses for the last 3 years. It could not find replacement of the company secretary and default on appointment was neither deliberate nor intentional, and it was due to reason which were beyond the control of the applicant. Further, requirement for the appointment is not applicable with effect from 1st April 2020, as the limit of paid up share capital prescribed in Rule 8A has been modified from 5 crore to 10 crores and hence prayed for lenient view. Though there is a default committed, there is a ground in interfering with the impugned adjudication order. ROC to the extent of reducing the quantum of penalty. Accordingly, penalty imposed are reduced from 5 lakh to 50,000 for the company and 1,44,000 to 15,000 on defaulting whole-time director. The appellant shall pass the penalty in a shall pay the penalty in 15 days. This is RD judgment dated 6 January 2022. Thank you so much for watching this update.